Afternoon, everyone. Thank you for joining us for this afternoon session. Just for those who are here in the morning, please bear with me. I'll just do a quick introduction. Um, by way of introduction, if you haven't been here already this morning, my name is Adrian Ang, and I'm an executive committee member of the Singapore FinTech Association. Now, how did we conceive of this series of three seminars? Well, we looked at the headlines, and as many of you will know, there were headlines about Shopee retrenching its staff. There were headlines about large cryptocurrency providers like Coinbase freezing employment contracts. So it was very obvious that there were employment issues in the industry, in the fintech industry generally. Also, you would have read about many companies that were facing insolvency-related situations. So, for example, no doubt, Whole Knot were given in principle approval by the MAS for their cryptocurrency license, but this was pulled, probably because of certain exposures that they had. You might have also read about Three Arrows, a fund management company that has gone insolvent because of its exposure to cryptocurrencies. And also, of course, Terra USD and Luna. You would have read about how this purported stable coins essentially went from a certain amount of value to essentially zero. And the founder is still at large, with the Korean authorities looking for him. So, we thought it would be useful for our members to put together this series of three seminars. Now, if you attended a seminar in the morning, that was basically geared towards employment-related issues and retrenchments. This afternoon session would be on insolvencies. And I'm very glad to have my colleague Alex Yo here with us today to run this seminar. Alex is actually a partner at Allen & Gladhill, and we are a full-service firm in Singapore, but we are essentially a Southeast Asian firm. So we've got offices in Singapore, of course, our head office in Malaysia, Indonesia, Vietnam, Myanmar, and these are all sizable offices. So, for example, in Singapore, we have about more than 500 lawyers. In Malaysia, more than 100. In Indonesia, more than 50. And in Vietnam and Myanmar, about 10 to 15 for each of these offices. So we are a full-service firm, both in Singapore as well as all around the various jurisdictions that I've mentioned. Alex specifically has been working very closely with a lot of our clients that may be insolvent, but also in relation to clients that are facing counterparties that are insolvent or could become insolvent. So Alex all of this is really fresh in his mind. And without further ado, I will hand the mic over to him for him to run the seminar. One last thing, if you do have questions, and I hope that you do have questions, please put them in the chat. We will consolidate the questions and try to answer them at the end of this session. But of course, if you think of a question you want to ask at the end, don't hesitate to ask those questions anyway, and direct them at Alex, not me. Okay, all right, Alex, please take it away.
All right, thank you very much, Adrian. Okay, so, well, thank you for joining me this afternoon for this talk about cryptocurrency, potential insolvencies, potential restructurings. There are a few tricks of the trade which I'm quite happy to share. Obviously, this is not everything that we know or are deploying in some of our current cases. Some of the more sensitive things you may end up reading in a judgment at some point. But there are some things which are quite well thought out or well publicized already on matters who are already on board. And that's what I hope to share here. I also understand that there are some attendees here who may not be so familiar with restructuring and insolvency law. it often, even for lawyers in other fields, is quite an opaque field of law that, you know, nobody really knows what's going on in there. So what I'm going to try to do during today's talk is firstly to cover, if anything, just the basics of restructuring and insolvency law, right? That, if you will forgive me, maybe a bit basic to some of the more legally trained or legally savvy members of the audience here. But the second thing I want to do is also cover cryptocurrency specific businesses and how restructuring and insolvency law has an interesting interplay, and what tips and tricks we can take away from that, right? So without further ado, this is what I hope to cover, right? And I'm going to be covering everything within a few broad headers. You know, what is liquidation? What is a scheme arrangement? What is judicial management? What's cross-border insolvency? And then tips and tricks will be sort of layered in between each of these overall headers. In a sense, this talk may be a little bit of a basic introduction to R&I law, but also at the same time, a bit schizophrenically, be hopefully a slightly more advanced analysis of how you can do interesting things for the restructuring or insolvency of cryptocurrency businesses. And I'm going to approach this from two angles. Firstly, if, touch wood, you know, you are in charge of a cryptocurrency business, or you're in a cryptocurrency business or firm, right, that is facing some kind of insolvency, what can you do to protect yourself, right, or restructure your debts? And then from the other aspect, if your counterparty is going into restructuring and insolvency, how can you protect yourself from their insolvency? Okay, so with that in mind, let's go ahead and look at first, starting with just a general overview of R&I law. Okay, R&I law has at least 6 different aspects to this, right? The best case scenario is at the bottom left of this slide, okay, which is nobody needs to file a formal proceeding, right? Even if a company is going broke, right? Best case scenario for counterparties of an insolvent cryptocurrency business, and even for the cryptocurrency business itself, is that there's some kind of consensual workout, right? That consensual workout can take any number of forms. It's not statutorily regulated, or rather, it's not statutorily prescribed in Singapore that, oh, your consensual workout must follow these particular elements. Okay, most of the time, consensual workouts are entirely between you and your counterparty, right? And what kind of clever deal you can come out from there. So let's say, hypothetically, you had a cryptocurrency business, right, as your counterparty, okay, and that cryptocurrency business is going broke. They're facing liquidity issues, or their net asset value has essentially crashed overnight after the whole Terra Luna collapse, and then Three Arrows, and then Celsius, and then all the filings which followed that, right? And they're in really a bad position, right? Now, you could sue them right now. You could liquidate them right now. You could do a lot of things against them, which I think you can see from the rest of this slide. But sometimes the best solution, in fact, is just to have a consensual workout, the bottom left-hand bit of this slide, which is just you agree with that cryptocurrency business, just, you know, instead of repaying me today, repay me in 6 months and repay me 80%. Give me equity instead of repayment of debt, right? So there could be a debt to equity swap, right? Give me tokens, or a slightly different form of token instead of repaying my debt in cash, right? There's any number of clever things that you can do in a consensual workout, which doesn't require, you know, formal proceedings, okay? It's where we get into the formal proceedings bit that this talk becomes a little bit more complicated, right? So on the left-hand side, you can see winding up, that's liquidation. That's if you want to kill a company dead, okay? Putting a company into liquidation eventually means that the company will be dissolved. It will no longer exist. A liquidator will be appointed to take charge of the business, okay, with the express purpose of shutting that business down, okay? So that's winding up, which is on the left-hand side of the slide. On the right-hand side of the slide, and I'm going to cover this in greater detail later, right? You see schemes of arrangement and judicial management. Basically, those are your rescue mechanisms. Those are proper restructuring law, not insolvency laws strictly, right? The company may be insolvent, which is why they need to go through that kind of rescue or rehabilitation type of insolvency proceeding, right? But the basic purpose of a scheme of arrangement or judicial management, 90+% of the time, is really to rescue a company which is in trouble, okay? And I'll cover that later. Then you see at the top of the slide, you see receivership. That's something I'm not really covering during today's talk, but basically that's a method for a secured creditor to enforce their security against a company, which is they appoint this independent insolvency professional called a receiver, okay? That receiver will go in and take charge of whatever secured assets were granted as security to the secured creditor, okay? So if a cryptocurrency business went broke, right? Before it went broke, it borrowed a bunch of cash, and as security for the borrowings, it granted some kind of a mortgage or a charge, right? The receiver would go in and enforce that mortgage or charge, okay? And then there's cross-border insolvency, which you see at the bottom of the slide. Again, I'll cover this later, but this is becoming increasingly common, right? Because many of these cryptocurrency businesses, right, have taken advantage of the quite, well, slightly more liberal approach adopted by the MAS in Singapore, right? So even though they may be incorporated, the head office may be incorporated somewhere else, right? They've either set up a branch here or they have incorporated subsidiaries in Singapore, right? So what could sometimes happen is you have the head company or the holding company, the ultimate parent, right? Somewhere in the BVI or the Caymans or wherever, right? Then you have subsidiaries in Hong Kong, in Singapore, in Thailand, in Indonesia. Okay, maybe not Indonesia, but you get the idea that there are actually insolvencies, live cases today, which involve multiple jurisdictions. And how do you make sure that your restructuring and insolvency has the effect you want in each of these different jurisdictions? That's an area of complexity, okay? So let's go through some of these categories one by one. And what I intend to do is go through the specific tips and tricks under each of these sort of general headings. So let's start with winding up or liquidation. Okay, like I said, this is the method to kill a company dead, right? So let's start with liquidation, right? Just as a very basic introduction, right? Liquidation is where a company can't pay its debts usually, okay? And eventually will be closed down, okay? So how that process works is a liquidator will be appointed. This liquidator is an insolvency professional licensed by the Singapore authorities, okay? Most of the time, there's one kind of liquidation which doesn't require a license, but that's less important, okay? That liquidator is typically an accountant, actually. Sometimes it can be a lawyer, but that's very rare. That liquidator's job is to collect all the assets of the company and realize them in the form of cash, okay? And then use that recovery, which is hopefully realized in the form of cash, to pay off the liabilities of the company first. In other words, pay creditors, okay? On a pari passu basis, that basically means broadly proportional with some exceptions, okay? So for example, employees enjoy a certain priority, right? So employees should be paid first before other kinds of ordinary creditors, okay? Secured creditors are right at the top, okay? They get paid first, right? Out of their security. The taxman gets paid first, but behind secured creditors, okay? And then after you pay off all your creditors, let's say you manage to pay off everybody, okay, the surplus will then go to shareholders. Okay, now, immediate thing to note here, if a company is broke, the shareholders are going to get nothing back, okay? Absolutely zero. Because this, as I said in the third bullet point here, right, creditors get paid first, shareholders only get the surplus. So if there's no surplus, if the company doesn't even have enough assets to pay off its creditors, right, then there is no surplus to distribute to shareholders anyway, okay? So liquidation can be exceptionally bad for shareholders of a company that's in trouble, okay? In the meantime, the company's business is supposed to stop, except if there's some like convenient way to wind down the company, you can do a little bit of further business if it's necessary to wind down the business in an orderly fashion. Okay, so if you have a contract which is nearly done, like you've only got 5 days left on the contract and it's 95% complete, then the liquidator may choose to just, okay, finish off that contract and close the company down after that. Okay, and as I said, the end result is usually the dissolution of the company. Dissolution means it's gone, it's off the register, it no longer exists as an entity. Okay, I've also set out here that there are 3 different kinds of liquidation, right? The main thing that you need to note is this, okay? Court liquidation requires an application to court, so it's probably the most expensive form of liquidation, okay? But the person who chooses the liquidator is the judge, okay? The court chooses who the liquidator is. So that's the first kind of liquidation. Second kind of liquidation is creditors' voluntary liquidation, meaning that the company itself initiates the process, okay? It's not the creditor doing this in sort of an adversarial manner. That's court liquidation, okay? But if the company itself wants to do it, it can just pass a few resolutions, right? Hold creditors and shareholders meetings, pass a director's reso, and the company will be in creditors' voluntary liquidation without needing any application to court, okay? Now, important thing to note about this second kind of liquidation, the creditor's choice of liquidator prevails. So there will be a creditors meeting, okay? If the majority of creditors prefer a different candidate for liquidator than what the company itself wanted, the creditor's choice will prevail over the company's choice, okay? Third kind is members' voluntary liquidation. This only can happen if the company is solvent, okay? Directors need to actually file something called a statutory declaration of solvency, okay? Because it's a statutory declaration, it's a very serious thing. If you file it falsely, it could be a potential criminal offense and whatnot, right? So typically this is only done when it's quite clear the company is solvent, okay? Meaning can pay all its debts within the next 12 months, okay? In this case, the shareholders are the ones who choose who the liquidator is, okay? So now turning to just focusing on court liquidation, and there are only a couple of things on this slide which I will cover, okay? The first one is who can apply for a court liquidation, okay? Now the company itself can do it, okay? But the most important thing is actually the second bullet point, which is a creditor can apply for court liquidation, and this is actually usually the only form of liquidation out of the 3 that I described just now that a creditor can actually initiate, okay? So that's the first thing I wanted to cover on this slide. The second thing I wanted to cover on this slide is what are the grounds for this application? Now, the most common ground for filing a court liquidation application is that the company is unable to pay its debts, okay? That's the first bullet point on the second half of the slide, okay? There are a whole bunch of other grounds on this slide. They're less common than the first one, okay? So whenever you have a cryptocurrency business which is going broke, okay, if let's say you are the counterparty, okay, you could file a liquidation application against that cryptocurrency business, okay? And you could file on the basis that this company is unable to pay its debts, it's going broke, right? Please put this company into liquidation. I don't advise this, but I have seen it happen multiple times before, where people file liquidation applications or threaten to file liquidation applications, right, as a very useful sort of pressure tactic to get back payment of a sum which is owed to you, right? Also because if you file for liquidation, that tends to be way cheaper than starting a whole trial against the company, like filing a statement of claim and going for a full trial against the company to get back your money, right? So liquidation applications to court tend to be a faster way of putting direct pressure on the company to repay the debt which is owed to you, which is outstanding. Okay, so that's one rather common tactic I've seen for cryptocurrency businesses, right? Even before filing the application, they will just issue demand letters and something called a statutory demand, right? Which threatens that we will put you into liquidation if you don't pay us. Okay, and that tends to be the galvanizing factor which causes businesses to come running to you and say, let's talk. Is there some deal which we can work out? Okay. The last thing I want to cover before, two things I want to cover before I go into the first cryptocurrency tip, okay, is this slide and the next slide. Okay, so let's talk about this slide. This is important only because I want to kind of explain to you what the consequences of a liquidation are, so that you have a framework to understand how you can use some of this to your advantage, if necessary. Okay, if you ever have, let's say, a counterparty going insolvent, or you're in a cryptocurrency business going insolvent itself. Okay, and you need to know what your options are. The first thing is just bear in mind, once a company goes into liquidation, the director's powers cease. Okay, there are limited exceptions to this. Most of them don't apply. Okay, and the reason why the director's powers cease is because power is supposed to be handed over and vested in the liquidator. So there's this independent person who comes in, basically displaces the directors, right? And runs the company during the period that the company is in liquidation. Okay, and that is the liquidator. Okay, and it's useful to have this independent outsider come in and run the business, or at least, wind down the business, right? Because you have some assurance as a counterparty that this independent outsider will be fair, right? Liquidation is also not a simple matter, as you can probably see from these slides. I'm simplifying things as much as I can, but even then there's a lot to go through, right? So you have some assurance that a professional who has done this repeatedly, like 1,000 times in the last 10 years, right, would be able to do this well. Okay, but it also helps you because this independent outsider who comes in can investigate what has gone wrong in the company. Okay, and I'll cover that in a while. If you act for a counterparty to an insolvent cryptocurrency business, right, having that liquidator look into bad things which have happened in the company can sometimes be important, right? That investigative function could uncover, founders of a cryptocurrency business who have transferred all the money to themselves, or use the money of the company to buy expensive yachts and good class bungalows for themselves and that kind of thing. Okay. Conversely, if you are in a cryptocurrency business that is going insolvent, right, you need to know what liquidation entails, because it could potentially have very bad consequences for you as a company, right? So it might be worthwhile telling the founder, hey, liquidation is really serious, right? If you're in the cryptocurrency business, you might want to advise management, hey, liquidation is very serious and has all these consequences. Okay. So employment contracts automatically terminate, okay, in a court liquidation, but not for voluntary liquidation. It's a weird discrepancy, but that legal technicality usually doesn't make a difference, because the first thing liquidators usually do is terminate employment contracts anyway if the companies really cannot do any more business. Okay, It's only if there's some business to wind down, right? Continue running for a while just to close off existing contracts. That's where the liquidator will say to certain employees, right? Not all. Can you please stay on for another month or so, or another few months, sometimes a year, right? To just help me close down this business in an orderly fashion. Okay. When a liquidation application has been filed, from that point on, please do not dispose of company property. This is something which has caught out a few of my clients, in fact, right? Where they think, it's only a liquidation application. It's filed by some kind of disgruntled creditor who we don't even think is a creditor. Therefore, I can continue running business as usual. Okay. The answer is no, you should not continue running business as usual, right? In fact, if you do that, potentially everything you did from the point the application is filed onwards could potentially be void. Okay. So that's bullet point 3 on this slide. Okay. Bullet point 4 is basically anytime you're suing a company and the company goes into liquidation after that, right? Your lawsuit against the company, your arbitration proceedings against the company are going to be stopped, okay? Because there's a moratorium on legal proceedings. Interesting one is even after you get judgment against the company, right? You can't enforce that judgment by attaching any of the company's assets, by getting the High Court sheriff to seize the company's property and sell it, because there's also a moratorium on execution of judgments. Okay, there's no moratorium on enforcement of security. There's no moratorium on set-off. There's no moratorium on repossession of land. So there's a number of things this moratorium does not apply to. Okay, but if you are suing a company in liquidation, if you're suing a company and it later goes into liquidation, right, your lawsuit is going to stop. Okay, so that's one consequence you just need to keep in mind. Okay, last thing I'm going to cover before we go into the first cryptocurrency tip. Okay, which is, there are a number of transactions which a liquidator has special powers. These are powers given to nobody else in law besides a liquidator, and later on you'll see a judicial manager as well. Okay, these special powers allow a liquidator to look back in time up to 3 years before the company was put into liquidation, or for a judicial manager before the company was put into JM. Okay, and set aside transactions which are unfair in some way, shape, or form. Okay, most common forms of unfairness that would lead to transactions being set aside are on this slide. Okay, first one, quite obvious, if the transaction is at an undervalue. Okay, if a valuable subsidiary which held 100,000 Bitcoin was disposed of for $1, right? That sounds like an undervalued transaction, unless that company has a whole bunch of liabilities I don't know about. Okay, so that is an undervalue. If you sell something which is worth a lot, but you sell it for $1, that's a very clear-cut transaction at an undervalue. Okay, unfair preferences. Let's say the company owes, the cryptocurrency owes business, cryptocurrency business owes money to 100 creditors, okay, but only decides to pay the director's husband. That's an unfair preference, okay, because it treated the director's husband better than all the other 99 creditors of the company. Okay, there are a couple of other examples here, but I don't think we need to go into them. In fact, the first two are the ones which we usually catch people out on. Okay, now the most important one here is the bit labeled security and trust, because this is going to lead to cryptocurrency tip number 1, which is liquidation. Obviously, as you can tell from these slides, has a severe impact on creditors and how much they can recover. Okay, if the company has $10 million left but owes $100 million to everybody, you can expect a 10% recovery. Okay, now how do you make sure that you, as a counterparty of a potentially insolvent entity, right? How do you make sure that you get 100% recovery? And that's the third bit in bold on this slide, okay? Which is take security or get some kind of trust, okay? Because liquidation generally doesn't affect secured creditors' rights, okay? It also generally doesn't affect trust property, meaning property where you retain the beneficial interest or your company retains the beneficial interest, even if the property is legally in the name of the entity which is in liquidation, okay? So that's where we come to cryptocurrency tip number one, right? The interesting thing is there has been fairly recent debate, as you can already see from the dates of the two judgments which I cited on this slide. Okay, there's been a debate about whether cryptocurrency should just be treated like money, right? Or can be a species of property which is held on trust. Okay, the usual rule is, let's say you deposit money in a bank. Okay, you don't own that money which you deposited in the bank anymore. Instead, all you have is a contractual right to be repaid that money which you handed over to, let's say, DBS. Okay, now if the same rule applies to cryptocurrency, then you're in trouble, right? Because you don't have a secured right, you don't have a trust property, you don't have property in general, like you don't have any kind of proprietary claim to cryptocurrency which is deposited with, let's say, an exchange. Okay, but the interesting thing is Singapore cases, and in fact this is starting to be kind of globally recognized as well in judgments in the BVI and judgments in England, New Zealand, and so on, right? That actually cryptocurrency is not just like cash. In fact, it is quite distinct. It is property which can be held on trust. Okay, so let's start with coin, right? The facts of coin versus B2C2 are a bit complicated, right? There was this trader who, coin basically made a mistake, okay, in pricing and selling cryptocurrency, okay, and a trader basically kind of took advantage of that mistake, but I don't think we need to go into that. And the question which a court was had to ask was, okay, is Bitcoin held on trust for the trader on the platform by coin, right? Or is this simply kind of a debtor-creditor relationship, just like a bank where you deposit cash with a bank and all you have is a contractual right, not a proprietary right for return of that cash, okay? And the court actually held that in this case, cryptocurrency is property, right? Which is capable of being held on trust, okay? Later on, 2 years later, this year, right? In fact, not too long ago, just a month or two ago, right? There was a Singapore judgment which said that Bitcoin and Ethereum are property for which a proprietary injunction can be made in respect of, okay? Now, what does this mean? This means that if you are dealing with a cryptocurrency business or a counterparty of some kind, right, and you want to deposit cryptocurrency with that entity, right, what you can do to protect yourself, right, is to expressly put in your terms and conditions that that property is held by, let's say, the exchange, right, on trust for you, okay? In fact, I know of certain cryptocurrency businesses, when they have customers which deposit cryptocurrency with them, they're actively thinking about trying to provide in their terms and conditions that any cryptocurrency deposited with them, the beneficial interest or title, in fact, still vests with the customer who deposited the crypto with them. Okay, and the reason why they want to do that is they want to reassure their customers that don't worry, even if I go broke, right, you will get back 100% recovery. Okay, so is that possible? Is that kind of arrangement possible? The answer is actually yes, right? Because of these two cases which you see on your slide before you. Okay, so the first bullet point deals with whether cryptocurrency can be held on trust. The answer is yes. Okay, just a point to note, there's a number of hoops you need to jump through to make sure that the legal relationship between the depositor and the custodian, right, is actually a trust relationship. Okay, and I'll go through that later. Okay, so it's not so simple as just providing in your contractual terms, like in a single line, this crypto will be held on trust. If you just do that and you don't do anything else, you will likely fail. Okay, so I'll come to that later. Okay, the second question is, can cryptocurrency be mortgaged or charged? The answer is most probably yes. Okay, in this case, what that means is, let's say you are lending cryptocurrency to, you are lending to a cryptocurrency business, okay? What you can do is you can specifically say that you should have security for your loan to that cryptocurrency business, okay? And that security, well, because quite often, what's the best asset that a cryptocurrency business has? It's probably the cryptocurrency which is in their possession, okay? Or under their ownership, okay? You can ask for cryptocurrency to be secured in your favor. You can ask for a mortgage or a charge over that cryptocurrency, okay? And just following the logic of the trust cases that you see earlier in the slide, plus some other authority, you probably can get a security arrangement over cryptocurrency, okay? And the third kind of thing, which is a bit simpler, right, but more nebulous, right, because it doesn't kind of follow any of the usual categories of, you know, trust or bailment or whatever, right, for traditional assets, right, is you just enter into like a title arrangement, okay, which is, if you want to minimize the impact of the custodian or broker's insolvency on its customers who deposit cryptocurrency with them, right, you can expressly provide in contract term, the contractual terms, right, that legal title to, or alternatively just a beneficial interest in the cryptocurrency will remain vested in the customer, okay, and title will, or beneficial interest will not transfer to the custodian, okay? So if you are a custodian trying to reassure customers who deposit cryptocurrency with you, this is something you can do, right? Conversely, if you are the counterparty and you are going to deposit cryptocurrency with a crypto business, right, and you're worried that they may go broke, right, because the market is volatile at the moment, for example, right, you can expressly contract that legal title will remain vested in you. It will not pass to the custodian, okay? And if this arrangement is held to be valid, right, and I'm going to come to why it might not be, okay, or circumstances where the court might say, I don't care what you provided in your contract, I view this relationship very differently, okay? But if this relationship were valid, right, then even if the custodian or broker goes insolvent, the cryptocurrencies will not form part of the custodian or broker's insolvency estate, but must be returned back to the customer, okay? Assuming it still exists. In quite a lot of these cases, after a big crash in prices, there may be margin calls. Cryptocurrency, which has been deposited with the custodian, may have been set off in by third parties and things like that. But barring actual loss of the cryptocurrency to some other third party, right? If the cryptocurrency is still sitting with the liquidator can't touch it. The liquidator must instead hand it back to you, the customer, because it is not part of the custodian's insolvency estate at all, or liquidation estate. It still belongs to the customer, right? It doesn't belong to the company which is in liquidation, okay? So this title arrangement slide seems a lot simpler than the trust structure just now, than the security structure that I covered on the previous slide, right? But there's some pitfalls, right? Because you don't really know this kind of title arrangement, I would typically see it in like bailment scenarios had physical or tangible assets been involved, right? But for the lawyers in the room, right, you would know that bailment over intangible property like cryptocurrency has never been recognized. Okay, to my knowledge, I don't know. Maybe there's a new case yesterday that I haven't seen it. Okay, but yeah, so some of the issues, well, main issue, I think 3 issues that I'll cover. Okay, the first one is on this slide, which is never mind the labels used by parties in a contract. Okay, the court is actually free to recharacterize the relationship. So even if you say, title remains with person X and doesn't vest in person Y, or this is a trust, this is not outright transfer of title and the beneficial interest to the custodian, right? The court is actually free to say, look, yes, that you've included one line in your contract saying this, but everything else in the parties' relationship is completely inconsistent with the trust. Okay, and I've listed some of the factors here. Many of these factors have actually come up in real live cases. Okay, there's one bullet point about the private key and whose knowledge or control it is under, right? That one is, I would say, more tentative because the law hasn't really quite dealt with this issue yet. Okay, so some of the factors that could lead to a title transfer, even if your contract says otherwise, okay, is where situations where, although the contract terms said one thing, which is the custodian has no title to the cryptocurrency still belongs to the customer, right? In that case, the custodian's balance sheet and audited accounts or internal financial accounts actually asserted ownership of the cryptocurrency. So it was actually listed in the custodian's balance sheet as belonging to the custodian, which was inconsistent with the contract terms of the between the custodian and customer, right? And so the court looked at this and said, look, your contract says title remains with the customer. Your balance sheet, on the other hand, says something completely different, okay? I am going to recharacterize the relationship to follow what your balance sheet says, okay? So please be very careful about how you do your accounting. Please also be very careful about how you pay capital gains tax, okay? Some of you may have actually, if you are in a cryptocurrency business, I know some of you are taking tax advice, right? On how to treat cryptocurrency, which, for example, may be deposited with you, right? In that case, right, in an actual life case, the custodian in that case actually paid capital gains tax on the cryptocurrencies which was in their possession, right? And that kind of led the court to again recharacterize the relationship as being different. Okay, bullet point 3 is the one which actually catches people out quite a lot. Okay, which is if the custodian has no title to the asset, but title to the asset remains with the customer, then the custodian should not be able to freely use the asset to charge it, to transfer it to third parties, to use it as though it's their own asset, right? So in situations where you have a broker who then freely uses the cryptocurrency as though it belongs to them, right? Even though it was supposed to be a mere deposit of cryptocurrency with them, with all title remaining with the customer, right? But if the broker sort of freely uses the cryptocurrencies deposited with them, right, then that's a factor which may lead the court to say, look, I don't care what your contract says, the parties treated this relationship as being very different. Okay. Bullet point 4 is something which came up in the Singapore Court of Appeal case in 2020, right? Which is you may say that the cryptocurrencies belonging to the customers remain the customer's property, right? The beneficial interest remains with them, right? Everything is held on trust, don't worry, okay? Title or the beneficial interest doesn't vest with, in that case, the exchange, okay? You may say all these things, But if you mingle the customer's cryptocurrencies with other customers' cryptocurrencies and with your own, with the custodians, right? And you don't segregate the customer's cryptocurrencies from your own or from other customers, and from other customers, right? Then that defeats a trust. Okay. So what I think was said in the coin versus B2C2 case is that segregation is a necessary but not sufficient condition for finding a trust. What does that mean? That means that if you don't segregate, there's definitely no trust, right? Even if you do segregate, that's not enough by itself, but it's good. It's helpful. Okay. Another one which I quite commonly see, and to be frank, this is quite helpful, obviously, for the custodian, right? Is if they say in their contract terms that they don't need to return, like let's say 100 Bitcoin was deposited with them, they don't need to return 100 Bitcoin. Okay. They can return cash instead, or they can return Ethereum, or they can return some other cryptocurrency which they find convenient to return. Okay. If that's the case, then it defeats the notion that the cryptocurrency is actually the customer's property, because the custodian's obligation doesn't actually require them to return that cryptocurrency. They can just return an equivalent quantity of some other cryptocurrency or cash. Okay. So that in itself already kind of defeats the finding of a trust. Okay. So just moving on. There's, I suppose, a couple of other risks that you need to look out for. Okay. The first one is I've had clients say, hey, this is all very interesting. Why don't we declare a trust? Okay, over everything. Well, be careful when you do that, because trustees actually owe quite extensive duties in law. And you can try to exclude these duties, but that runs into two problems. First, that there's an irreducible core of fiduciary duties which a trustee owes, which cannot be excluded. Okay. And the second is, the more you exclude your duties as a trustee, the more the court, the more you risk the court recharacterizing the whole relationship to be instead be something else. Okay. Then the last thing I want to cover is sort of a risk for the customer. You know, like you may feel that, okay, having the property be mine, okay, and it's not a loan, it's actually the cryptocurrency remains my property, right? Well, what happens if the custodian gets hacked and the cryptocurrency gets stolen? In such case, unless you can show negligence or breach of custodian duties or things like that, or some point to some contract term, right? The custodian or broker doesn't actually have an obligation to compensate the customer for the loss of the cryptocurrency. Remember, it was your property all along. If it was lost through no fault of the custodian, right, then your property is lost and the custodian has no obligation to compensate you. Okay. So there's a risk for the customer as well if you try to be too clever and have all these, you know, title arrangements and so forth. Okay. So second form of insolvency proceeding, right, is schemes of arrangement. Okay. Now this one can be very simple. A scheme of arrangement sounds very complicated. It's basically a rescue mechanism. And how the rescue mechanism works is the company will propose a plan, a restructuring plan or compromise to its creditors. And then if it can pass a vote of its creditors by 3/4 in value, majority in number, right, and get court approval of the plan, which is fairly simple once creditors say yes, okay, then the plan is passed and the plan is binding on all creditors. So this is what is typically known as a cram down, right? Only 3/4 of your creditors in value said yes, but the scheme is binding on 100% of your creditors, okay? Now, the most important thing here is the binding effect of a scheme, that it can actually restructure your debts, because a scheme can do a whole bunch of things. It can impose a haircut on all your creditors. Everybody could recover 50%, for example, Okay, it could extend timelines for repayment, right? Instead of repaying in the next 6 months, it could repay in the next 6 years. Okay, and there's any number of terms that you could come up with in the scheme, which are quite clever. Okay, that's the first important consequence. The second important consequence is the scheme moratorium. Okay, which is very wide. In this case, it blocks people from suing the company which is going through a scheme. Okay, but it also blocks enforcement of security. It blocks potentially related parties from being sued. So if the scheme company holds a bunch of subsidiaries, right, you can get a moratorium not just against the scheme company itself, but all its subsidiaries as well. And the best part is you can even get this moratorium to potentially apply outside Singapore as well. Okay, so that's what a scheme of arrangement can do. Now, how does this help you in the crypto space? Okay, well, a few things, right? First is, if you look at recent crashes, there's a bunch of themes which I always see, right? One is there's liquidity pressure because a market collapse creates this, right? And also impacts net asset value. So in the short term, you might have difficulty paying people. And in the long term, your balance sheet also looks quite negative, right? Or may look quite negative, okay? But your fundamentals of your business may actually still be strong. Maybe there'll be a recovery someday, right? Second thing I always see, suspension of withdrawals and redemptions, okay? The other thing which is quite common, right, is volatility, right? It's very hard for you to value or forecast in the future, right, what things are going to be worth, okay? So as a result, you need to think about how to restructure this, right? And the first thing is, if you look at recent cases, the Singapore courts have actually granted protection in the form of moratoriums against claims, okay? This also can give the company quite a lot of breathing space to work out restructuring plans, okay? It also allows you time to have sort of an investor process, right? Allows you time for discussion with interested parties because nobody can sue you during the time that the moratorium is afoot, okay? And it also helps, and not to brag of our Singapore courts, but there is quite a large degree of international recognition and confidence in Singapore's restructuring laws. So we have been globally recognized. In fact, Singapore insolvencies have been supported and assisted by the New York courts, the London courts, and so forth. Okay, so that helps, obviously, right? But what else can you do in the crypto space, which is interesting? Like, how can you restructure your business? And this is where I want to turn to a case study, okay, which is the Bitfinex case study. Now, some of you may have heard of this. Yes, there are a bunch of controversies which have attached itself to this case, right? But the basic facts which I've set out on this slide are a little bit of a success story, like setting aside the other controversies, okay? Which is, you know, Bitfinex was hacked. They lost 120K in Bitcoin, right? That's about 36% losses. So everybody was going to take a 36% haircut if they went into liquidation, okay? Now, instead of going into liquidation, right, what Bitfinex did was they issued BFX tokens, which were traded on a secondary market, and they allowed investors to sort of gamble on a return to insolvency. So if they held on to the tokens, they could redeem it in full for $1 per token, okay? Now, initially, these tokens were traded at a ridiculously low price, okay? There were a whole bunch of rumors that this is just a scam. But, you know, over time, they managed to sort of restore confidence in these tokens. One step, which was quite significant, was they actually bought back some of the outstanding tokens, right? And then within, I think, 8 months, Bitfinex announced that it was going to pay off its debt in full, right? So this idea of a cryptocurrency business going into insolvency, going into restructuring, and that's the end of the story, that's not true, because there are interesting things that you can do for cryptocurrency businesses in particular, right? Such as, this option of issuing secondary tokens. And, this is no secret. It's nothing new. Celsius has announced that they're going to try to do something similar. Hence, I can talk about it during this talk. Okay. Third and final form of restructuring that I'm going to cover, okay, is judicial management. Okay. Now, much like schemes arrangement, this is most of the time a rescue mechanism. Okay. The only difference is for schemes arrangement, they run their own restructuring. The company still remains in control of itself. Okay. Main difference is that in judicial management, an independent outsider, right, an insolvency practitioner, usually an accountant, will run the company for 180 days and has the benefit of a whole bunch of moratoriums, which we covered in the previous slide, right? In order to protect the company and allow it to rehabilitate or restructure successfully. Okay. Now, there's a case study for this as well, which was Hold or Not, right? Which was a bit of a pity, right? Because they wanted to restructure, right? But right before going into the supposed restructuring, right, they lost their license to provide digital payment token services, right? So bottom line there is get advice from good regulatory lawyers such as Adrian. The second thing is, the company applied for its own judicial management, right? But the court basically said, look, I've taken a look at your nominee for judicial manager, right? He is a very reputable insolvency practitioner, but I'm not going to appoint your nominee. I'm going to appoint one suggested by another stakeholder. Okay, so what did this mean? This meant that the management lost control of their own restructuring because the judicial managers that were appointed were not the ones the company wanted. Okay. Now, there's other things such as cross-border insolvency. I'm not going to deal with this in detail. The main thing I'm going to cover is actually crypto tip number 4 on this slide, okay, which is about investigations. Now, let's be frank. This is not true of all crypto businesses, okay? Let me caveat by saying that first of all, okay? But for some of the crypto businesses that I've seen, they are basically run by very young, brilliant, confident people who don't have, decades of experience in running, established companies or major list codes or things like that. So what does that mean? That means that they're brilliant in terms of, the business ideas that they have, maybe, right? But it also means that there sometimes is a surprising lack of corporate governance. Some of the standard things you would usually see in running a big company, you just don't see in some of these crypto businesses. Okay. And I'm not going to name names here because, that might be sensitive to some of the cases which are in court already and have noticed that this is how these companies have kind of been run. Okay. So what does that mean? Quite often it means that you need to conduct investigations on how cryptocurrencies have been diverted, sometimes been used to pay for somebody's personal yacht, or good class bungalow or other property somewhere in Manhattan. You need to run investigations on what happened to the cryptocurrency, because sometimes these different companies were not run properly. So the assets of one company were actually intermingled with the cryptocurrencies of another company in the same corporate group, right? So depending on how the cryptocurrencies are held, you can actually use blockchain analytics. You can use forensic work to ascertain who owns what. Okay. So that's the last tip that I have. Any form of insolvency, even cross-border insolvency, will, so long as there's this independent outsider, being a liquidator, a judicial manager, or even a foreign representative in cross-border insolvency, would give these powers of investigation to an insolvency professional, who then can use special things that only exist, honestly, in cryptocurrency businesses, such as blockchain analytics, right? To identify who is supposed to own what and what happened to certain assets. Okay. So thank you for bearing with me for the last hour. I believe next up we have Q&A. Does anyone have any questions? Feel free to type that into the chat function, or was it the Q&A function?
The chat function, well, either would be fine.
Yep.
Okay, I mean, does anyone else, does anyone have any questions that they want to raise verbally? That's fine as well. There's a question about who do you use for blockchain analytics to ascertain valuations? Lawrence, sorry, Alex, do you know the answer, or is it just a commercial thing?
It's a commercial thing, right? Yeah. So typically, in the cases I've been involved in one case, I acted for an insolvency professional who already had established relationships, so they handled that on their end. In another case, it was recommended by the client already, so I didn't need to look into who they used for that.
Okay, any other questions? Well, if not, then thank you so much, everyone, for taking the...
Adrian, I've received a question. Just give me a second, yeah. Trying to pull out the question. Somebody asked a question about the different forms of cryptocurrency and how that affects restructuring. Just give me a second, yeah. So the question is, do we foresee any difference in the handling of restructuring exercises for companies that primarily issue stable coins versus DPT versus NFT?
So maybe I'll put so for everyone's benefit, I'll just talk about how these are assigned from a regulatory perspective, right? So if you talk about stable coins, basically there are a variety of stable coins, but the idea is that there is a promise by the issuer that each stable coin is supposed to equal to a certain amount of fiat currency. So for example, one USDT, which is a stable coin, would always be equal to $1, right? So that's stable coins. Separately, you have normal cryptocurrencies like Bitcoin and Ether, and that's considered digital payment tokens in Singapore, or DPT in short. But do note that in Singapore, stable coins, single currency stable coins like USDT and USDC are also considered DPT. So DPT consists of both your normal conventional cryptocurrencies as well as single currency stable coins. The third category, NFTs, I mean, I suppose it will depend on what NFTs are. I mean, I suppose in the most common example of NFTs would be digital art. So your holding an NFT would give the user usually a license or right to enjoy the digital art in his privately. It usually doesn't give him the IP ownership over the digital art. So those are the three categories. So single currency stable coins, which are DPTs, cryptocurrencies, which are DPTs, and NFTs, which are usually digital art. So Alex, do you wanna?
Short answer, besides, I suppose, regulatory differences, there's less of a difference in terms of how you would go ahead with restructuring these entities. Some of the differences that I've seen in cases basically arise from how volatile some of these different assets are. So in one case, the relevant DPT in question was quite a bit more volatile than your usual stablecoin, right? And that led to potential questions by a judge, right? Of, well, how sure are you that your restructuring will actually succeed, right? Because remember that the judge if he's going to grant an order allowing your scheme arrangement to proceed or allowing your judicial management to proceed, the judge needs to, at the very least, have a sort of basic smell test, right, of how realistic your chances are to succeed, or is this just a, like, not really a genuine restructuring, right? So that sometimes is a concern if the form of NFT or DPT might be a bit more volatile in price, right, compared to your usual stablecoin.
Okay. Anyone else? If not, thank you very much for joining us today. I hope that most of you can join us for tomorrow's session, which is about dispute resolution, specifically what the Singapore International Mediation Center can offer. Okay, on that note, thank you very much.
Thank you, everyone.